Okay, welcome everybody. It's 12 o'clock. It's time to start the inaugural Hill Wallach Power Hour. This is the first of what we hope will be many informative webinars that we are bringing to you to help solve your community association issues. I have 5 of my distinguished colleagues with me: Jessica Baker, George Greatrex, Greg Shivers, Lauren Lightman, and Terry Kessler. And the premise is that each attorney is going to have between 5 to 10 minutes to talk to you about a specific topic, and then we will move on until the next topic. So what we're going to do is jump right into our first polling question, which we are going to launch now. So you should see a question come up on your screen. When you see that question come up, please answer it. We're going to give everybody around 15 to 20 to 30 seconds to respond, and then we'll give everybody the responses. Okay, we're going to close the poll and we're going to share the responses. So we have about 32% of you are board members. The greatest percentage of you are community association managers. We have some association professionals, vendors, and we also have a couple other. So thank you. So let's move on to the next slide. So first slide. Legal disclaimer: although we are all attorneys, and although in some cases we are probably your attorneys, we are not acting as your attorneys today. We are giving you general legal advice and hopefully answering some of your questions that may come up during the presentations. So if you have a specific legal question about your association, please, please, please contact your association attorney. Next slide. A couple more things before we get started. This webinar is being recorded and may be used at a later date. So if you have an issue with that, feel free to log off. We are going to try to take some questions during the webinar. Although it does say use the chat function, we're not going to use the chat function. We're actually going to use the Q&A function. We may, if we have time during the individual presenters portion, we may answer questions at that point, or we may hold some of the questions to the end. If there are things that we can respond to through the Q&A, we will try to do that as well. Also, this webinar is approved for 1 hour of CE credit for community association managers through CAM-ICB. However, you must stay on for the full duration of the webinar in order to get that credit. You will be getting your certificate within the next probably 7 to 10 days after the webinar is over. So with no further ado, let me turn the program over to Lauren Lightman, who is going to talk to us about COVID issues. Lauren.
Thank you, John, and good afternoon, everyone. Continuing COVID-19 issues is a very hot topic and a topic near and dear to my heart, primarily because I talk about it all the time. Next slide, please. Oh, we're going to do polling question 2. Are we? Oh, okay. We're going to go. We're
going to skip the polling question 2 until the end of your presentation, Lauren.
Okay. Before I get to the details of this slide, I want to start out with a couple of general observations from my frequent communications on this issue. The first one is that when we were talking about this issue a year ago, my advice to the boards was, if your risk tolerance in general is at or near 0, then the answer as to whether you should open things up in terms of operations, in terms of amenities, was probably an easy decision, which was no, you were going to leave things shut. My sense of things is that this year, the risk tolerance by and large is not quite at 0. It may not be 100% in terms of comfort level, but it certainly, for the most part, is higher than 0. Also, in these discussions, especially in the meetings with the homeowners, I am seeing that my sense is that if things are remain shut again, or maybe shut if you haven't shut before, is that you're going to be faced with somewhat of a revolt among your residents and your owners, because the sense of things overall is that people do want to get back to some level of normalcy, and people see using their amenities, their clubhouse, their pools in that same discussion. So I think boards are going to be faced with a decision as to how much to open up and how. So in terms of a snapshot of where things are, and right now, as of March 1st, 2022, we're in pretty good shape. According to the CDC guidance, most people in the United States today are living in areas where those who are healthy do not need to wear masks indoors anymore. And we see a number of states across the country lifting their indoor mask mandates. In New Jersey, as of Monday, March 7th, you're not going to have to wear masks and facial coverings into the schools, which is a huge change from the current and prior positions. At the same time, of course, we have to acknowledge that the state COVID immunity law expired as of the end of 2021. So that will be taken into account. I'll be talking about that in a couple of minutes. And the state average number of cases and hospitalizations continue to fall. They're trending down, even as late as yesterday afternoon when I checked the numbers. We're still doing okay in New Jersey. So for the moment, things are good. Next slide, please. So in terms of reopening the amenities, we're going to start with that first, because that is the question that is seems to be top of the priority list. And the questions I get frequently are the liability and the insurance concerns. Primarily because we don't have a statewide COVID immunity law anymore. You know, it seemed like last year, as soon as that law was adopted, we were bombarded with, okay, we're going to open, that's it. You know, magic light went on and everything turned at that moment. The fact that we don't have that law on the books anymore does not necessarily mean you can't open, but I think had we been having this discussion a month, 2 months ago, there would be more of a debate potentially, because even though nothing is foolproof, okay, nothing is 100% foolproof, but certainly with that immunity law, it certainly raised the bar that people would have to prove a case for COVID exposure on association premises against the association. It made it much, much harder, and it cast a wider net. So in terms of that wider net, when you look at the possibility of tort immunity amendments, which I have been asked about frequently, even last year, I had some boards that wanted the adoption of tort immunity. And of course, this is the legal concept where the association would amend its declaration or its master deed to provide for a safeguarding of sorts against claims based on bodily injury, not specific necessarily to COVID, although the concept is it would potentially encompass COVID claims as well as claims such as slip and fall, which was initially the primary role of tort immunity prior to 2020 and COVID. Two caveats, however, with respect to tort immunity. Number one, unlike the statewide COVID immunity law, it has to be adopted by a 2/3 vote, a 2/3 affirmative vote of the members. So it's not automatic. And second, it only applies to the unit owner and the unit owner's spouse. Does not apply to guests or other visitors, tenants, family members, and the like. So it does provide potential protection, but it's certainly not foolproof, and it's certainly not as wide as the COVID immunity law was from last year. Now, at the same time, when we're making this decision, we look at the likelihood of successful action against community associations. Sitting here right now, I am not aware of any successful actions in New Jersey, indeed in any other state. That doesn't mean there aren't potential cases pending. I'm not aware of any. And of course, as things open up, maybe in 2020, it would have been a little bit easier for people to potentially prove a case for COVID exposure and bodily injury. But today, when you have people in essence resuming their normal lives, I think it's going to be very, very hard to prove. I even know of cases where even back in 2020, people got COVID who were homebound because people came into their homes and arguably, may have given them COVID. So it doesn't mean it's zero. It just means the likelihood is going to be that much lower. I'm also asked frequently about indemnification of board members, and that certainly is something to consider. This is where you need to talk to your association attorney, because while most governing documents do provide for indemnification, there could be situations where maybe that's not the case. So you need to talk to your attorney about that. If you are going to decide to open, potential steps to implement, certainly signs and waivers, that was in place for the most part last year. We want people to know they're using the facilities at their own risk. And that could apply to non-residents too. You know, you may not be able to get non-residents to sign a waiver in the case, let's say, of an open playground or an open tennis court where you can't control access. So if you put a sign up, make it clear, using at your own risk. Again, you may want to get with your attorney to discuss signs, waivers, regular cleaning, for example. Right now, we are not under any kind of executive order or health department guideline like we were last year in terms of the cleaning, the clubhouses, the gyms, the pools. You have to use more common sense this year, I think. You know, if you have certain high use times, you would clean more, but there's no hard and fast rule that says you have to clean every 30 seconds every time somebody touches a surface, that kind of thing. What's important is implementing rules, particularly for amenities like the playgrounds and the tennis courts, which access can't be controlled, to let people know what the rules are. You know, sometimes I get questions, well, how do we enforce? We put a rule in there, but no one's patrolling on a regular basis. We don't have a manager on site to constantly be monitoring this. My advice on that is generally, look, you know, you put a rule in place, for example, overcrowding. And if the board notices that the rule is constantly being violated, you reserve the right to close the amenity. And I think a big issue this year is going to be whether to restrict guest access. That's a big question, whether you don't allow guests altogether or you restrict it. Next slide, please. I think if you take nothing else away from my remarks today, I want to impress upon this, the process to decide whether to reopening. In 2020, a lot of boards were forced to make very quick decisions on meetings, for example, on closing clubhouses, closing pools. But I think over the last 2 years, one thing we've learned is that the homeowners don't want to be left out of the process. So I would advise that you enunciate specific requirements if you are going to reopen. Adopt at an open board meeting. You can certainly have discussions either by email or behind the scenes if you want to have an executive meeting with just the board and you discuss pros and cons. But when you go out there and you make the decision, you want to make sure you put it on the agenda ahead of time so people know it's going to be discussed. You discuss at an open meeting, and then once you make that decision, you publish it to all the members and the residents, and it should be reflected in the meeting minutes so that going forward, people understand how you made the decision, what you based it on, and maybe any relevant discussion that took place at the meeting. So in future years, people know what that was based on. Next slide, please. Meetings and social gatherings. I know we're going to talk in a few minutes about virtual meetings, but again, this is another decision that's going to have to be made in terms of virtual, versus in person. Are you going to have, if you have in-person meetings, are you going to require masks? Are you going to require social distancing? Electronic voting amendments are something I'm being asked about now, so that people that do not want to attend a meeting in person for member meetings, they could still cast a vote in board elections, and they could still vote for member questions. Do you want to potentially still offer a virtual option for those people that do not feel comfortable yet going out to meetings? Social gatherings, limiting the number of attendees, still signing waivers for those people that come in. And again, the types of gatherings that you're going to permit, whether it's on-site gatherings, do you wait for the summer? Do you wait for Memorial Day weekend, have it outside versus inside? Are you going to start, renting clubhouse space to members, or maybe put that off for now? That's a question I'm getting too. The bottom line is that you have to utilize a common sense approach while, again, we have to monitor any changes that could turn this, on its ear. If another variant comes out, if the numbers start going up again, and to gauge the climate of your community. And again, I think the communication is key, and hopefully things continue to go forward in a positive direction, and we keep moving toward normalcy. So with that said, I will turn it back over to John. Thank you very much.
Thank you, Lauren. And before we get to Greg, we are going to move real quickly and do our second poll question. So in a second, you should see the polling question pop up on the screen. Please take a second to respond, and then we will announce the results. Okay, we're going to close the poll and we're going to show you the results. So is your board planning on opening the association amenities? 41% say yes. 33% say that you plan on fully opening next, 41% are already fully opened, 33% are opening in the next few weeks, partially opening 21%, and not opening at 6%. Okay, our next topic is Greg Shivers, who's going to talk about the legislation regarding virtual meetings. Greg.
Thank you, John. Good afternoon, folks. So first, let me just give you a quick history of the legislation involving virtual meetings. You were always able to have virtual board meetings. The Nonprofit Corporation Act, since at least 1969, has allowed that. Of course, they didn't know anything about Zoom back then, but they did telephone conferences. During the pandemic, the governor passed an emergency bill that allowed for virtual membership meetings, but it was only until the state of emergency was lifted. So in January of this year, and thanks in large part to the LAC, the governor signed a bill. It's an amendment to the Nonprofit Corporations Act that allows virtual meetings to be held for membership meetings as well as board meetings. So that legislation has just a couple of requirements. First of all, the board must establish procedures. So you do have to have a written document. You need a resolution. You don't need to amend your bylaws, but you do have to pass a resolution. So call your lawyer and say, we need a resolution for virtual membership meetings, and it's a pretty simple task. And what that resolution has to include is, give me the next slide too, Tricia. Okay, so what that resolution has to include is, number one, reasonable measures to ensure that the member participating remotely is a member or a proxy of a member. And the question everybody asks is, well, what does that mean? What are reasonable members to make sure that there's nobody from the outside listening in? And of course, you can't 100% ensure that nobody else is listening in. But I recommend that at the beginning of the meeting, you read a disclaimer. I'll give you some suggested language in a couple of minutes. And you also, when you send out the notice of the meeting, you should make clear to the members that they should not share the link with anyone who is not a member of the association. So it's my opinion that if you do make that disclaimer at the beginning of the meeting, that will fulfill this requirement of reasonable measures to ensure that the member participating is actually a member or a proxy. The second requirement is that each member has an opportunity to participate remotely and hear or read the proceedings relatively concurrently with the meeting. So remember, in membership meetings, every member has a right to be heard. In board meetings, you do not have to allow the members to participate verbally. Of course, it's always good practice to allow that at the end of the meeting, but it's not required by law to allow that. But in a membership meeting, you do have to allow each member the opportunity to be heard for the good of the association. So that's one of the requirements of this bill as well. And the third requirement really is repetitive of the Condominium Act and the other acts pertaining to homeowners associations, and that's you have to record and maintain a record of any votes or other actions taken. So basically, it says you have to keep your minutes just like you would in an in-person meeting. Next slide, please. So this is just a sample of a disclaimer that you could read at the beginning of the meeting. I would, again, when you send out the notice, put in bold letters, do not share your link. And then you could use this language. It says, this meeting is for members only and the content of this meeting is confidential. If you are not a member of the association, you are directed to leave the meeting immediately. If any member sees a participant that you know is not a member, please raise your hand immediately and let us know. If you are not a member, your continued attendance on this Zoom session is unlawful and the association will take appropriate legal action against you. The association and its members do not consent to the taping of this meeting, and anyone taping it is in violation of state and federal wiretap laws. So if you have an outside person who gets the link and they tape it, and believe me, that has happened. I recently had an association where somebody from the outside taped it and sent it to the newspapers. They are technically in violation of the Wiretap Act, because you cannot intercept the communications between two people that do not consent to you intercepting it. That's a little bit strong language. You can use it or not, but that's just an example of something that I suggest that you say at the beginning of the meeting, so that you have fulfilled the requirements of the legislation, that you've taken reasonable measures to ensure it's just members. Next slide, please. So some of the benefits of doing virtual meetings is, number one, you can do combo meetings. So now that we're getting back to in-person meetings, I strongly recommend that you still allow Zoom. You can, set up a laptop and allow people to watch the meeting and participate in the meeting by Zoom. We all know that you have a lot of problems getting quorums, and this makes it a lot easier to get a quorum, because anyone participating by Zoom or by telephone counts towards the quorum. You can organize a meeting on fairly short notice. So particularly board meetings, one of my associations in particular, because the new Radburn regulations make it very clear that you have to vote on everything at a public meeting, and you can only use the emergency exception in rare occasions. You can just organize a quick board meeting, say there's not going to be any participation by the members, and literally it can be a 5 or 10 minute meeting where you vote on, say, a new contract that has come up or something that has to be passed before you have your regularly scheduled board meeting. And the other thing is that when you use a Zoom meeting, you can control the crowd. And we have a number of associations where you have problems with people shouting out in the middle of meetings, and this way everyone is given a fair chance to be heard without being interrupted. I said the mute button rocks. Sometimes that mute button is very valuable in controlling your meetings. Next slide. So just these are recommendations on how to run a virtual meeting. I recommend you keep everyone muted and have the president recognize people when it's their turn to speak. Basically, follow Robert's Rules of Order. And it's important that whoever is running the Zoom make sure that everybody else is muted, so only one person is speaking at a time, because that gets very jumbled. You can't hear what people are saying, and then they're not being given a fair opportunity to participate. I recommend that when you start using Zoom, that you give all your members a quick tutorial on how to raise your hand in Zoom. It's not like this, but there's actually a little button that you can push to raise your hand. I don't know if it'll work. You can see that my hand is raised there. And that way you make sure that everybody that wants to be heard has an opportunity. Make sure you start your meeting with the announcement that I talked about, and make sure that you take minutes and you basically conduct the meeting exactly as you would an in-person meeting. So those are my tips about virtual meeting. And John, that's all I have.
Greg, a couple questions that came in, I just want to hit before we move on. So first question, are tenants permitted to attend but not participate?
Only if your bylaws or the bylaws permit it.
Okay, next question. So do you recommend that open annual meetings not be recorded?
It's funny, I think probably those of us on the board have different opinions about that. My recommendation is always not to record meetings. I think that you take the minutes and that becomes the official record of the meeting. Does anybody else on the panel disagree with that? Have a different opinion?
It's been said that really the only reason that they should be recorded is just to give the note taker the opportunity to review their notes and be accurate with regard to the minutes. But then as soon as the minutes are done, that the recording be erased.
But if you're going to record it, then I mean, don't the rules require that you make that recording available?
That's correct.
So I think you risk that if you record it.
Yeah, but the only exception may be is if you become aware that somebody will be recording the meeting, an attendee, and that has come up often, then you have a decision to make if you're going to have the official recording.
Okay, one more question, which I think is a good one, and I'm not sure there's a great answer to. So if we're having a virtual meeting and the governing documents allow for nominations from the floor, a member is nominated from the floor, how should this be handled?
Well, that's interesting because I actually think that the regulations that allow nominations from the floor is actually contrary to Radburn, right? Radburn, the whole purpose is for everybody to know up front exactly who's running, and allowing nominations from the floor gives people the opportunity to sneak candidates in the back door, which I think is directly opposite to the whole philosophy of Radburn. But since the regulations at this point do allow that, you do have to allow it. And you know, you do it the same way as you do with questions. You ask for, are there any nominations? And you have people raise their hand, and you allow them to make the nomination. Happy to let anybody else jump in on that one.
Before we move on, anybody else want to respond to that? I think that's a good answer. Okay, before we move on to George, we're going to do one more polling question. Okay, the question is your board planning on continuing to hold meetings virtually? Give everybody a couple seconds to respond, and then we will share the results. Okay, we're going to share the results. So is your board planning on continuing to hold meetings virtually? 38% said yes, we're going to remain fully virtual. 29% we're going to hold some meetings virtually. 25% we're going to hold hybrid meetings, and 9% said no, we are going to hold all meetings in person. Interesting. Okay, it is now time to talk about structural issues, and I'm going to turn it over to George Greatrex. George.
Thanks, John. Hi, everybody. Good job, Greg and Lauren. I think it's fair to say that the main legislative issue that we dealt with last year in 2021 was COVID and immunity and all of the different things and procedures that came out of COVID. I would expect that here in 2022, one of the main legislative issues that we're going to be dealing with in our industry, not just in New Jersey, but across the country, is legislation that regards inspections of our buildings and funding of our reserve accounts. So strap in for an awful lot of discussion and interesting debate over these particular issues, because it is coming. And it's going to affect us in our industry. So I'm going to start. I only have a couple of slides, so follow with me here, folks. I'm going to start with the basic situation we're in right now is that there is no statutory law or administrative regulation that requires periodic structural inspections of condominium or cooperative buildings, although, as many of you probably know, most, if not all, association governing documents do impose a duty on the association's board to maintain, repair, and replace, that's the terms that you're going to see a lot, the association's common elements in accordance with accepted industry standards. What does that mean? How do we know what needs to be done? Well, you have to do inspections, right? Some of you are probably thinking, well, wait a minute, doesn't the DCA already require certain inspections? And the answer is yes. As we all know, the dreaded 5-year cyclical inspections do occur and have been occurring for a number of years. However, you should probably, you know that those inspections only deal with the generally the insides of the unit, and it addresses simple things like maintenance and habitability within the units themselves, things like CO2 detectors and that sort of thing. Next slide, John. And this may be surprising to you, but there is also currently no statutory law or administrative regulation that requires condos or cooperatives to conduct a reserve study or to fund reserve accounts to address future maintenance, repair, and replacements of their residential building components. But again, you know what your governing documents say, and in the fiscal responsibility section of your bylaws, it generally will say that an association board is required to maintain and fund reserve accounts for such things as deferred maintenance, component replacement, capital improvements, which the board in its judgment and discretion deems appropriate. So that's really where the rubber meets the road right there, right? It's even though the documents say that the board should be or must be maintaining those funds and those accounts, what exactly does that mean? So sadly, it took the tragic collapse of the residential condo building in Surfside, Florida, to kind of bring this issue to the forefront. And it is now going to spur an awful lot of legislative activity. It already has in Florida. And we're in the process here in New Jersey, especially folks like, or states like New Jersey, which are coastal states, where we're dealing with a lot of high-rise condos along the ocean, which brings its own set of environmental factors that we all have to take into consideration. Okay, John, next slide. So currently there is a bill that's being drafted or researched and drafted in the New Jersey Senate Community and Urban Affairs Committee, and that's a committee that's chaired by our friend Senator Troy Singleton, who the CAI Legislative Action Committee has a very good relationship with. And we have in fact been asked to assist the senator's office in drafting this legislation. He considers us a great resource, as he should, with regard to community association industry in New Jersey. And so this bill, while it has not yet been introduced in the Senate, I expect that that's going to happen fairly soon. And there's going to be some robust debate about it. It is going to put certain requirements, mandatory requirements on associations around our state, and those requirements are going to cost money. So again, be prepared. So what I expect that this legislation is going to include will be certain requirements which for the first time, associations are going to have to, with regard to certain covered buildings, must be inspected by a licensed structural engineer during the building's pre-construction, construction, and post-construction phases, specifically with regard to their primary load-bearing systems. Now, you're going to hear that term a lot in this debate, and because that it has to do with number one, this doesn't apply to homeowner associations where there are single-family detached homes. What we're mostly talking about are condominium buildings and cooperative buildings, especially those buildings that are built with levels on top of each other. The language I expect in the bill are going to say that covered buildings are those residential buildings having load-bearing concrete, masonry, steel, heavy timber, or a hybrid structure, and also buildings with podium decks. Now, podium decks is not what you think it is. It doesn't mean a deck that you walk out on and sit on a chair. Podium decks means that the load-bearing system is that you have one floor on top of another such that the weight is dispersed downward in the building. And could that apply to a two-story condominium building where you have a floor, a first level unit and a second level unit? Yes. But it also, of course, is going to apply to the high rises that you see mostly along the coast, where you may have 10 or even 20 different floors where you have these load-bearing systems. And these are the types of buildings that are going to need to be inspected. The second requirement that I'm expecting to see is that the associations must maintain adequate reserve funds to make certain that the required maintenance and repairs to building components and common areas can be made. At this point, that means that there's going to be a statutory law in place that says you must maintain adequate reserve funds. While some of your association documents, or if not most of them, require those kinds of reserves, I have to believe that some of you in the audience are affiliated with associations that either don't have those reserve accounts or have woefully underfunded reserve accounts. This law is not going to allow that to continue. Of course, the $64,000 or maybe $64 million question is, what does it mean to have adequate reserve funds? And so that takes us to that next bullet point, which is that the law is likely going to require that associations have to undertake capital reserve studies on a periodic basis to identify and assess the adequacy of the association's capital reserve funds to make sure that we meet the anticipated costs associated with maintaining the structural integrity of the buildings that the association is obligated to maintain. And those studies, I expect the law will require, must be made by a credentialed reserve specialist or an engineer or an architect who is licensed by the state. The bottom line of it is, folks, is that we're not going to be able to just put a little bit of leftover money into your reserve every year. There's going to be studies that are required to tell associations how much it's going to cost to make sure that there is money there to make these repairs, and the association is going to have to do that. We don't know what the penalty provisions are in the statute. That's something that will be hotly debated, I suspect. But as you probably know, one of the problems with the tragic collapse in Florida was that even though issues, severe structural issues were identified prior to the collapse, the funds weren't there, and nor was the will there to generate those funds to make sure that those repairs were timely made. So that's something that the legislature in New Jersey is going to be very keenly aware of this year and focus on, and to make sure that, at least in New Jersey, we will not have the same kind of tragic events that they experienced down in Florida. That's what I got, John.
Thank you, George. Now we're going to turn it over to Jessica Baker to talk about legislation regarding discriminatory covenants. Jessica.
Thank you. On November 8th, 2021, Governor Murphy signed a new law addressing discriminatory language in property deeds and governing documents. The law imposes an obligation on associations to review and remove any discriminatory covenants in their governing documents. So I'm going to go more into this obligation in just a minute, but I first want to touch upon the significance of this law. I've been practicing in this area of the law for several years, but until fairly recently, I did not have any idea of how restrictive covenants were used in governing documents to prevent people of certain races or religions from residing in certain communities. I'm going to very briefly discuss an important case that shows one example of such a restrictive covenant. The case is Shelley versus Kramer, which was heard by the US Supreme Court in 1948. As a very brief background of the facts, in 1911, 30 owners of properties on both sides of a street in St. Louis, Missouri, signed an agreement, which was recorded, that provided that for 50 years, the properties should not be occupied by any person not of Caucasian race. And this agreement covered 47 parcels of land. Just to give you a little background here. In 1945, the Shelleys, who were African-American, purchased property that was part of this restrictive covenant. The Shelleys had no knowledge of this restrictive agreement when they purchased. A few months later, Kramer and his wife, who owned property also subject to this alleged restrictive covenant, brought an action to enforce the restriction. The case made it all the way up to the US Supreme Court. The court ruled that discriminatory covenants like this were unenforceable. In the years that followed, the Fair Housing Act and the New Jersey law against discrimination were enacted. So you may be wondering, if these restrictions are not enforceable, why is this new law now important? So until now, there was no law requiring the actual removal of this language from documents. So discriminatory covenants, like the one in the Shelley case, may still exist in governing documents and property deeds, which again, not enforceable, but may discourage someone from buying a home in a community. And this is one of the reasons why the law I'm about to talk about was enacted and is so important. Next slide, please. Thank you. So what this law means: the new law provides associations need to review their governing documents for restrictive covenants as prohibited by the New Jersey law against discrimination. The law prohibits covenants that restrict ownership, occupancy, or use of property based upon race, creed, color, national origin, ancestry, age, marital status, sexual orientation, familial status, disability, liability for service in armed forces of the U.S., nationality, sex, gender identity or expression, or source of lawful income used for rental or mortgage payments. That was a mouthful. This review should have been conducted by February 6, 2022, which was 90 days from the effective date. Any restrictive covenant found must be removed, and the law provides that a vote of the membership is not required. So this is important. The board can act here on its own to remove this language from the governing documents. Another important aspect of this law is that a member can bring certain language from the governing documents that they believe is an unlawful restriction to the board's attention. The board must review within 30 days of the member's written request. If the language is found to be an unlawful restriction, the board would have to remove within 30 days of their determination. So 2 final quick points about this law. The law also provides that any deed recorded on or after January 1st, 2022 is prohibited from containing a reference to a restrictive covenant. The law also provides a process for removing of such a language from a deed for a property owner. So there's 2 additional interesting points. So the takeaway from this segment is that associations have to conduct a review of their governing documents. If you have questions about conducting this review or questions about any language in your governing documents, make sure to speak to your counsel. And now back to John.
Jessica, we got the question that I think you were anticipating. What about over 55 communities?
So those are permitted under the law. There is an exception for age-restricted communities.
Okay, so thank you, Jessica. Our last presenter today is going to be Terry Kessler to talk about some collection-related issues. Terry.
Thank you, John, and good afternoon, everyone. I'm going to talk about the Fair Debt Collection Practices Act, which is a federal law that was enacted in 1997 and went into effect in March of 1978. And it was enacted to protect consumers from deceptive, abusive collection practices. And in my opinion, this law was meant really for to protect a consumer from large mortgage companies, hospitals, utilities, companies where there was an unfair advantage to these large companies. It was hard to get, an answer. And I think, though, unfortunately, it does apply to community associations. And so an association is still, community associations are bound by this law. And so we have to follow it. And it's been interpreted to apply to the collection of assessments. And so you need to be aware of it. And there's a new regulation that I'm going to discuss, and that has some new laws. And I think that new regulations, and I think that those regulations are going to have to alter how the associations behave when they collect assessments, even if it's, even if it's not going to apply directly to the association, it's going to apply to anybody who works with them to collect those debts. So The Fair Debt Collection Practices Act started enacted a federal law. There are states that have their own separate collection statutes, but New Jersey's not one of them. So we go by this federal law. In 2010, the Congress enacted the Consumer Financial Protection Bureau. They set it up to make rules and regulations to implement the Fair Debt Collection Practices Act. And there were a lot of questions as to, how things are to be operated. For example, with the onset of emails and things like that, nobody knew, if that was fair to contact a consumer by email. And with Regulation F, which was enacted in 2020 and became effective on November 30th, 2022, that provided some guidance as to what is required by the FDCPA. And I say that guidance lightly because it did make it even more confusing in a lot of people's opinions. So let's just get to the basics. Next slide, please. So in order to understand it, you need to understand who a debt collector is. And a debt collector is any person who uses the mail or in any business whose principal purpose is to collect a debt. And as of 1986, it applies to attorneys and it applies to third-party collectors. So it's not for the collection for original creditors. So the community association is the original creditor, but what about the manager? And I'll get to that in a minute. Consumers, it applies. So what is a consumer? We sometimes refer to them as a debtor, but they are called consumers under the act. And a consumer consumer debt applies to personal, family, and household transactions, not businesses. So it also applies to deceased consumers. So if you have a unit owner who's deceased, the estate, they are considered a consumer under the act, and so you're subject to the regulations of the Fair Debt Collection Practices Act. And what about investor owners? For a period of time, we thought, well, if the person's buying the unit because they're an investor, it wouldn't apply to them. They're not a consumer under the law. But there's been cases recently where a family, they purchased the unit, say in Florida, because they think they might live there, maybe at the Jersey Shore. They don't live there now, but they have tenants in there. And the courts have interpreted that to mean to be that they are not investors, they are consumers, because at some point they intended to live in the unit, even if they never lived there. So there are cases out there. There's some scary cases that, always need to be taken into consideration when talking about this act. Now, the real scary part about this act is that it's strict liability. That means you're liable regardless of your intention. So you send a letter to the unit, but the unit owner doesn't live there. Their tenants live there. And it doesn't matter that you didn't know, unless you have procedures set up to guard against that and those procedures fail. You're strictly liable and you're going to be liable. So what the Fair Debt Collection Practices Act does, it prohibits certain conduct of a debt collector. Now, for managers, I told you that I would talk about that. So the FDCPA exempts fiduciaries, and it exempts those authorized to collect the debt before it became due. So under those two exceptions, a manager would fall, because the manager is typically a fiduciary and they're authorized to collect the debt before the debt became due. However, you have to be careful here, because if the manager was only hired to do financial services, I think that the cases could hold that the manager is a debt collector under the act. So so far, managers it has not been extended, but you need to be careful. And so since it doesn't apply it only applies to third-party collectors, and the association is not a third party, anything that a manager would send, my advice would be to send it directly from the association. It doesn't need to be signed, just say, you know, from the association. Next slide, please. So the FDCPA enacted Regulation F, which went into effect in November of 2021. And this gave some details about, you know, what's required and what's not. So what is an excessive phone call? Well, according to the FDCPA, the hours of contact can only be between 8 a.m. and 9 p.m. local time. So that means that you have to, it can only be between 8 a.m. and 9 p.m. local time. So if you're on the East Coast and you're calling somebody on the West Coast and you call them outside that time, that's a violation. But you may not know that because a lot of cell phones that people use, I mean, I know I have a client that lives in New Jersey, but he has a cell phone from Texas. So it's really difficult. And you know, that you just have to know that's the law and be careful when you're calling people. Also, if the hours are inconvenient to the consumer. So say the consumer says, I work nights. You know that the consumer works nights. It's inconvenient to call them during the day. You cannot call them during the day. If they mention that to you, you may not call them during the day. If they're at work, it's presumed that their place of employment is not convenient. So, not convenient and also, you know, improper. So you would have to get special permission from them to call them then. So when a manager is talking to a consumer, a debtor, I would get all this information down, whatever information you can get from them about where they work or when they want to be contacted. It's very important because you need to transmit that to whoever is going to collect the debt for you, particularly, you know, your attorney. The next one is very confusing to me. It's no call frequency. You can call no more than 7 times in 7 days. Now, I'm assuming that that means that you can't leave messages or call their phone and your number comes up more than 7 times in 7 days, because the next requirement is only once to a consumer in 7 days unless you obtain express permission. So if you've spoken to them, if you've got on the phone with them, you've talked to them, then you need to, you can't call them again for a week unless they give you permission. So you need to remember to get that permission. And then voicemail. This is another very interesting and scary part of the regulation. You can only leave them, your business name, your request to the person to whom they should reply, and your telephone number. And you have to leave those things. Optionally, you can say hello, the salutation. You can give them the date and time of your message and suggested time for them to reply to you, and who the consumer is to speak to if the consumer is going to reply. Next. Email communication is permitted, but you must have the consumer's consent or you can't email them, or they email you. If they email you, you can email them back. But when you do that, you should make sure that you put in your email, you know, I'm going to email you. Is that okay? Try to get whatever you can, whatever approvals you can get. And also your emails will have to say that you have the option to opt out, and that's supposed to be clear and conspicuous. And you will notice that we've now added that to our emails so that a consumer debtor can opt out of emails from this office. Once they opt out, that's it. They say to you, don't call me anymore. I'm not interested. I'm not paying this. You can't call them again. You can't email them again, and you can't communicate with them again. Unless you're going to advise them that you're terminating collection, or to advise them that you intend to file a lawsuit or take other legal action. Another violation is if you are represented by, if a consumer or debtor is represented by an attorney, unless the attorney is unresponsive or directs you to contact the client, you can't contact them. Next slide. seeking unjustified amounts or time-barred debt. So in New Jersey, the statute of limitation on a contract is 6 years. So you cannot seek to collect or threaten to collect any amounts that are over 6 years old. So please act promptly when pursuing people who are not paying their assessments. Also, if late fees or fines are not authorized in your governing documents, then this would make it a violation of the Fair Debt Collection Practices Act to try to collect them. Communication with a third party. So suppose you try to call them and well, originally I told you about contacting the tenant, sending the letter to the tenant. That's a violation. Particularly if you know that there's a tenant in the unit, or if you try to ask the tenant, who are you sending your money to? I mean, and to get information. You're allowed to get location information, but you're not allowed to talk about the debt or try to get it collected. So a lot of times the lenders will contact an attorney's office, and this is more for an attorney, but again, for the manager, when the lender contacts you and says, because you're sending the super lien letter, how much is due? That letter needs to come from the association. It needs to be on association letterhead and should come from the association, because you're talking to a lender, a third party, and you're revealing information about that consumer or that unit owner to a third party. And so it needs to come from the association. I would not send it, from the manager. Maybe they can contact you to get more information, but it should come from the association. Okay. You can't falsely report to a credit agency. You can't threaten legal action if that action's not permitted or you're not going to do it. And you must maintain your records for 3 years after the last collection activity. And I believe that's my last slide.
She's got one more, right? Is that it?
Oh, okay. Sorry.
So make it
very
quick,
important
Terry.
one. Very quick. Very quick. So what Regulation F did is they sent this model letter that you can use, and you get a safe harbor, which means that if you use this letter, it's presumed that it's okay, but you have to follow all of the information. And John, if you want to show the letter, that's my next slide. It's bizarre. This is what our collection letters are looking like after November 31st, December 1st. You can see there's a tear off at the bottom where they say that they're going to pay or they dispute the debt. It has to have an account number, which is up at the top, a reference number. It has to have, their address. It has to have time and date where to call you. It also gives you in that second paragraph how you can dispute the debt and what you can do. And you have to give information about like the Consumer Protection Bureau and other email websites and information to call or to find out about your rights as a consumer. And if you look, the last thing is over on the left is where we itemize the amount of the fees, and that can't be changed. And it's based on, they call it the itemization date, and it goes by the last statement date, the last date that the debtor paid, a date, the date of the judgment, or a charge date, which is something that is an accounting term that associations don't use. So we've been going by the date of the last statement, but that's assuming that associations are sending statements. So you may be getting requests from your attorneys to start sending statements to unit owners so that we can base it on that. And all they want is whether there's interest charged. So there's an issue because, our fees continue to accrue and there's not necessarily interest, but there's late fees, but this just isn't taken into account by the Consumer Protection Bureau or the regulations. So there's going to be more litigation on this. It's going to be interesting how it plays out, but just to briefly let you know, That's my brief summation of this act and the new regulations.
Thank you. Tom misspoke, and she said it went into effect on November 30th, 2022. It went into effect 2021. So it is in effect now, and that's a federal statute. That's the Fair Debt Collection Practices Act. So that does apply to New Jersey and Pennsylvania and all the other states. So again, we went a little bit long. We said we were only going to keep you an hour. So if anybody does have any questions, we are going to try to get to them, and we will try to respond to them offline. I just want to thank everybody for attending today. I also want to thank all our speakers, Jessica Baker, George Greatrex, Terry Kessler, Lauren Lightman, Greg Shivers. Our next webinar is going to be Tuesday, April 5th. Just to let everybody know, because we did get a couple questions, we are going to provide you with a copy of the slides, and we're also going to provide you with the link to the recording. That probably won't happen right away, but you should be getting that in the next couple of days. Finally,
I just wanted to ask one question. I wanted to answer one question here. Someone said that, you know, associations have resolutions to collect rent. And I think that that's important, and that because that comes up a lot. And so don't ask your attorney to collect the rent, because that would require your attorney to write to a third party. But as long as the association sends the letter, again, like I said, that would apply. Okay, go ahead.
Thank you, Terry. So we are going to be doing these webinars more frequently. So if you do have a topic you'd like to hear discussed on a future webinar, please email info@hillwallet.com, or you can always contact one of today's presenters and we will put it on the agenda. So again, thank you all for attending, and I hope you enjoyed the presentation.